All right. Hello, everyone, and welcome back to the fourth session of the special HIPAA huddles on the proposed HIPAA privacy rule changes. This is the fourth and last. So thank y'all so much for joining us on this journey as we discuss these proposed changes. Before we get started, we are going to do our shameless promotion of our brand new podcast that we launched back in October. So Armchair HIPAA is a podcast for compliance officers by compliance officers. And what we mean by that is we're telling your stories. So I get the privilege of interviewing compliance officers and other folks in healthcare organizations that have the responsibility for HIPAA compliance. So if you or someone you know is interested in being a guest, please email or call Bethany. Her contact information is right there. And I also want to give a big shout out to everyone that has already participated. We really appreciate the trust you've provided us and letting us tell your story. Okay, so a little bit of housekeeping before we get started. This call is being recorded and everybody will receive a copy of the recording as well as the slide deck tomorrow. So this is a special HIPAA Huddle series that is discussing the proposed changes. So we are still holding our normal monthly HIPAA huddles. So our next regularly scheduled HIPAA huddle is tomorrow at the same time, 1 o'clock Central Standard Time. And that's our regular monthly scheduled HIPAA huddles. So right now your mics are on mute, but you are able to unmute them if you have questions. So we're going to have slides that say huddle up. If you have a question, you can either message it to Cheryl Stevens or to the everyone, and Cheryl will let us know those questions throughout, or you can unmute yourself and just speak up. We would be happy to hear you. While you're speaking, if you choose to turn your video on, you can do that as well. And just remember, like with all of our HIPAA huddles, the more you participate, the more we all gain. So we love hearing from you, your perspectives, your questions. Please share everything you have with us. All right, so the first thing we're going to do is recap, because this is the last of the special HIPAA huddles, because we are going to finish with all of the proposals today. Erin and I decided that we are going to do a brief recap, which reminds me, I forgot to introduce Erin. Erin MacLean is our guest. Erin is a healthcare consultant as well as an attorney that focuses in on healthcare compliance. She is an expert in all things HIPAA, and we are so privileged and happy that she's joined us over the past 4 weeks to go through these special huddles with us. So with that, Erin, let's get started. So the first thing we're going to recap are these new definitions. So the OCR has proposed 2 new definitions. We went over this in part 1 of the HIPAA huddles, and this are the special huddles. So the EHR is redefining the OCR is redefining what an EHR is, as well as defining what a personal application is. So Erin, do you have anything that you want to add on this slide here?
No, we just need to remember that there's reasons they're doing this. And, it relates to sort of this overall goal of these proposals, which is care coordination, access to information, exchange of information, goals from, under the 21st Century Cures Act to HIPAA to everywhere. Really having these definitions later will help us to define what needs to be disclosed. We're moving into this space where this electronic exchange is going to be, the key of the way that we get information in the future and the way that access is done. And I think they're doing a good job recognizing that there's some lack of clarity in this area. And so who knows when this will be, put in place, but at least we know it's coming and there's an intention behind it.
Absolutely. All right, so the next thing we're going to recap is the individual rights of access. So we've boiled down a huge section of these new proposed changes to 4 bullet points. Again, this was in part 1 of the special HIPAA huddle. So if you want to hear all of the detail on this, you can always go to the HIPAAtrek YouTube page and listen to that. We'll also be sure to include all the links in our email follow-up to you tomorrow. But Erin, what do we need to really remember here under the right of access proposals?
Well, what they're going to do is they're going to strengthen the right of access that already exists. And in the the proposals, they made clear that there's misunderstanding or apparent misunderstanding as to what individuals can currently access or how they can access it. So although they're adding on to that access by trying to allow for videos to be taken and photos to be taken, then what we're really going back to, and this is what we've done this entire series, is there's a right of access now, and there seems to be some confusion around it. And so we should all go back and make sure we know that, so that as we move into these proposals, we have a good baseline, and we can then adopt proposals as they are finalized in rules. So, going back and understanding the right of access, and that it's different from obtaining information through an authorization process, a HIPAA compliant authorization. So that's important, both right of access for the individual and right of access for the individual to provide for third parties. So I think that's probably the bulk of what we covered.
Awesome.
Yeah.
Also in part one, we covered these fee for records. So, because everybody's always curious on how they can charge for records. So how is the OCR clarifying or changing how we can charge for providing patients and others with access to the records?
Right. Well, one way, as we know, is they're trying to clarify their what their position is under. Is, you say CIOX, I think I've said CIOX, but the cases that have come about that clarified what fees can be charged and can't be charged, and then also the third part, the request for information to be sent to third parties through electronic means, of course, is going to be huge in the future. And really changing the way in which we perceive we can not only charge fees. There's a lot of encouragement there too, of making sure that you're not charging fees to individuals who can't pay, right? There's a lot of encouragement in the proposals for that. But also they really laid out a very good map of exactly what they're going to allow and not allow in fees. And I think if anybody wants to really know that, they should go look and see exactly what they're going to allow in the future and not allow. And also just, again, clarifying what the status of the law is now. So they did a good job of that, and then saying where they wanted us to go. So again, we'll talk a little bit about that notice of privacy practices today, and how that, they're looking to also modify that to ensure that that notification of fees is very clear, and that it's given prior to the charging of the fees. I know we talked about that too.
That's a big one. Yeah,
Yeah.
absolutely. So healthcare operations is getting clarified in really big ways. And this was in part two, so our second special HIPAA huddle, where we really detailed out these healthcare operations. And this is the O of TPO. So what are some of the big things that we need to remember on healthcare operations and how it's being clarified?
I think the proposed rules, they really reminded us that you currently can share information for treatment purposes for care coordination and case management. They also shared with us guidance on where you can, find more information on what you can and can't do. And then last week we moved into how you can do that for individuals with mental health, and how you should be doing that for individuals who have mental health treatment going on. So what they're proposing to do in the rules is make very clear how you can do that, especially with non-treatment providers such as social service agencies, et cetera. And that's going to be really interesting when they do bring those clarifications out for us in final rules. But I think what we need to remember is, again, right now, we can be exchanging information, sharing information for treatment purposes with other providers and individuals who are providing treatment related services. And of course, in some places, the minimum necessary requirements would apply when it comes to sort of providers that fit further out into ancillary services on treatment related. But for treatment providers, especially under the 21st Century Cures Act, we're moving into a place where if you can, you should, in order to accomplish care coordination and case management. And the question is, are we? And, I
Right,
think we can all go back and look at that.
right. I mean, Yeah, so here's the minimum necessary standard we kind of talked about. I think that one of the biggest things they said was that it is sufficiently flexible, right? Like we've got this flexible enough.
And it's
So
flexible now.
correct. Correct. And they're going to be just doing a few other like tweaks to that, which is amazing. So here's where we're going to get into some of the bulk of this. Like the next two slides are on the PHI disclosures for substance use disorders and serious mental illness. And one of the things like you just mentioned is a lot of this is clarification.
Right.
Some of it's new, but most of it's clarification. And it's stuff that is being clarified in the privacy rule because it was introduced to us with the Cures Act and then with a lot with like especially SUD in the CARES Act, right? So these are things that we should already know about, and now HIPAA is just kind of pulling in and clarifying.
Right. So the OCR, we can see why they're doing this, this professional judgment to good faith belief. We talked about how they wanted to make sure that, it's in rule, that it's understood that individuals who don't necessarily have professional licenses can be making judgments under good faith beliefs. So that's one clarification. And that, with the clients I work with, they're already doing this, but they're calling it professional judgment. And then when it comes to that serious and imminent threat versus serious and reasonably foreseeable threat, I think that is going to be helpful. It's going to keep people, it's going to allow the covered entities and the employees within the covered entities to be able to act on something that they think might happen and they can reasonably foresee without necessarily having to say that it's going to be imminent. That's the issue is, can I say something is imminent? A lot of times I can't, and I don't know. So I think this is going to be helpful. It will be helpful to lawyers, because this is sort of the legal standard that a lot of lawyers work under anyways. Right. It'll be helpful in them advising how to utilize this. And I guess we'll just see in the final rules how it all comes out, but it seems rational and reasonable. And, they're trying to make sure that there's balance, and we can see that in the proposals.
Right. So, and here we see for the SMI, for the serious mental illness, and it has some of the same clarifications, but here we have a nice link to current guidance. So we can reiterate that some of this is stuff you can already be doing, that the OCR with these new proposed changes, a big bulk of this is clarification. And so we can actually point to current guidance where these things are already kind of spelled out for us. So, and you guys don't worry about trying to like jot this link down super fast. Like you'll be able to get it from the deck there. Hold on one moment while I yell at my child. I'm on a webinar. Sorry, I work from home. Yay! All right, so with that, after you guys heard me fuss at my 15-year-old, let's huddle up. So are there any questions on the recap that we've given?
So yeah, hi, this is Cheryl. Can you hear me? I'm not on mute. No, I'm fine.
You are fine. You are good.
Fine. Welcome, everybody. First question, you just clarified, will we be able to get a copy of the presentation? So yes, that will be coming to you in the follow-up email with the recording. And when we say patients will have a right to take photos or videos of their own PHI, do we mean written records, or is this including recording visits and the creation of PHI?
Of course, we don't know what the final rules are going to say, but the way that it was described is the latter. So, or both, I should say. So, they are proposing, if you go back in and look at that part of the proposals, they are proposing that this be allowed in visits and that it be allowed in a context where they can take, screenshots and audio. So what we'll be looking at once the proposals are finalized is really the scope of what does come out in the final rules, and also what is allowed in us limiting that or directing it in our policies and procedures. So we have a process that allows what's being required, but we also don't have disruption and disturbance to our processes in treating individuals as this happens. And so, of course, we can't do anything until we know what the final rules are, but we can anticipate that that's what they're looking toward, and we can kind of start figuring out how we can work that within our organization as we anticipate these changes in the future.
Okay, thank you. And that's all we have for questions at this point in time.
So I'm so glad. All right, so on to the last few things that we have. So we're going to cover 3 new sections of the proposed changes with this one, starting with the notice of privacy practices. I know we all love that every time we have a new HIPAA change that we get to mess with our business associate agreements and notice of privacy practices. And this time is no different. So Erin, why don't you start walking us through these proposed changes on the notice of privacy practices?
Right. So OCR's heard, from what we understand in the proposed rules, that requiring individuals to sign acknowledgements and then keeping them for 6 years apparently is, burdensome, especially if you're doing it in a paper setting, and has been burdensome. And so they're proposing to remove both of those requirements and replace them with what the OCR believes is going to be a better way to both inform patients and also, relieve the burden on providers. I mean, I guess we'll get into that a little bit more, but we'll see if that ends up being the case. I think that in their cost estimates, they're seriously underestimating what these changes will entail. But I think in the end, it may end up being an easier process. So we can go into that and discuss that more. I think we have some other slides related to that.
Right. I think that patients are going to be super excited that they don't have to sign this every time they see the provider. So that's good. So record keeping. So eliminating that 6-year retention requirement for the NPP acknowledgement. We just talked about that. So, and they will be eliminating the 6-year retention requirement because they're also removing the requirement for us to have to sign that acknowledgement, which I think is a good thing, right? And I know that it's going to have a little bit more burden up front with us getting our processes in place for how we will communicate to the patient their new right to be able to discuss the notice of privacy practices with us. But I think that in the end, it'll be good.
Right.
So we're also going to make some pretty substantial changes to the NPP. Erin, can you walk us through what these changes are?
Yeah, they discussed having a model, and it doesn't look like that's where they're going to go and having a model NPP. It does look like what they're going to do is require a specific header that has specific information in it. One is how to access, the right of access piece, how to access PHI. And the other is really how to file a complaint, right? And then how to reach the individual in the organization that is handling these pieces. And by reach the person, it means actually reach the person who's going to, answer the phone. So they talked a lot about really having that personal person available and good information so that the patients can access that person. And then, of course, where they receive the notice of privacy practices and where they can discuss the contents. Again, that individual, right? How do we discuss the content? It appears as though the anticipation is that most of this will be done through website posting of this information and also done in the setting. I'm not sure exactly how that's going to be in final rules, so I'm not going to, go there, but that there is going to be a change in what's required in the header and what information the individual sees sort of immediately looking at that notice of privacy practices. That designated person is going to be interesting. Like you put here, are they on site? Yeah. What is the contact information? Are people able to reach them?
Those were specifically spelled out in the commentary there, where it was, the question was asked, like, is this designated person on site or are they off site? And then it said contact information, including phone and email, right? So, which led me to believe that the OCR will be requiring that phone and email to be on the notice of privacy practices. So that will be really interesting to see how that shakes out, because I know so many hospitals and clinics that on their notice of privacy practices, it says privacy officer, no name, the address, and typically it's the address of the hospital or the clinic. And then it'll have the phone number of the clinic, not a direct line. So is that okay? Is it not okay? We don't know. And then most of the time we don't see email addresses. And if we see an email address, it's like HIPAA@hospital.com or privacy officer@hospital.com. And so it'll be really interesting to see how this all shakes out.
Right. And what the final rule says about this and the clarity that they give us in what's going to be required.
Right. All right. So here we have some more things on the notice of privacy practices. And this is our last slide on the notice of privacy practices, y'all. So bear with us for just a few more minutes while we go through this. So what are the last few things that we really need to understand, Erin?
Yeah, so there was a lot of discussion about wanting to include in the requirements that the rights of access be spelled out, like we discussed in our program that we did on what's going to be required in rights of access and fees and third party, designations for that, and where an authorization is required and where an individual can request the information be sent to a third party. And then, of course, if the final rule adopts the ability to request information from another provider through a covered entity, or another covered entity through the covered entity, I anticipate that will be part of what needs to be in there. And really they're saying improving a customer understanding of the scope of operations through which information is shared. And that gets to the case management piece and care coordination to the extent it's involved in operations. And then also better spelling out of what treatment and payment means. So they're saying that they're going to be looking for better examples and more clarity in the examples, and probably more breadth as to what is shown in the examples, so that people better understand what these things mean. And I know we spell those out in examples now, but they're saying they're going to look for more. So again, I'm really curious to see how these final rules shake out, because I want to know what sort of clarity they're going to give us.
Right. So the NPP section is still TBD, to be announced.
Right.
Right. So this one is really interesting, Erin, and we were talking about this because I personally have never utilized the TRS system in all my years of working in a healthcare administration. That was never something that came up. However, the Office for Civil Rights, or the OCR, being responsible for HIPAA compliance, I actually applaud them for putting something like this in here, because they're really, the reason why HIPAA compliance falls under the OCR is we have a right to protect our privacy and security, and we also have rights on how our data is utilized. And so now the OCR is putting this express consent to be able to disclose to disclose PHI to TRS systems and not require a business associate agreement.
Right. It just is clear from the language in this proposed rule that they realize that the current rule just does not provide assistance in the ways that they need this to work. So for instance, in many cases, the TRS systems, they operate independently. They're not necessarily related to use by just patients, but also by employees, and that they had anticipated previously that individuals would be able to consent to having PHI discussed or released during calls that are handled by TRS. And that process just is not the way it works anymore, if it did before. And so what's happening is the TRS system is automatically engaged it's independent of the hospital or the covered entity. And it's not just being utilized by patients, but it's also being utilized by staff. And from that perspective, it was just too hard to figure out how to ensure that that consent was obtained, or that there was a BAA, because of course, the TRS system may not be a business associate, you know, and
Right.
in the way it's being used. So it looks like cleanup to me, but it also, like you said, it highlights the OCR status as ensuring there's not discrimination and there's no discriminatory practices, and that they had a rule that they recognized was a burden when it came to ensuring communication amongst all types of individuals
Right.
in a covered entity.
I think this will be a rare accountants for folks to come across, but I think it's a super important one. I'm actually excited about that one.
Right.
All right, so on to our very last topic before we huddle up for our last time on this special HIPAA huddles, the armed forces. So the OCR did not leave out our men in uniform. Erin, what do we need to know on the new proposed changes for the armed forces?
Right, or women in uniform, right?
Or women, that's true. So I was using men generically, but okay.
So of course, the men in uniform and women in uniform were not left out previously. There's information that can be requested and shared outside of an authorization as an exception to the general rule under HIPAA for armed services. And what they noticed here is under the USPHS and NOAA, that those individuals served similarly to armed service individuals or armed forces individuals, that they were active duty, and that in order for the federal government to have information that they needed to make sure that these individuals were eligible for service, that they needed to have the information. So I see this again as another cleanup, where they're bringing these two organizations into the same rules that we already, utilize for armed forces. And so again, it was just a reminder that we do have an exception for requests for the armed forces, and we should have policies on that. And if we don't, it's a reminder that we need to have them in place. And then once the final rules go into place, that we add, these additional pieces. Also, that until the final rules are in place, that we don't have it fully integrated. So, for all of these rules, it was really good reminder to me, to my clients, to say, are we in this place that the OCR says we should be in? Because
Right.
there were a lot of spaces where they say, you should already be doing this. We think you can already do this. We are clarifying that this is what you should already be doing. And that's helpful, and even if it does take a couple of years for this to roll out, we know where we need to start from, and that's great. And this is the same thing. We need to remember that for the armed forces, we do have a specific exemption for that, and we need to know how to follow it.
That is I loved that, Erin. All right, so huddling up and getting questions for the last time from all of you guys. We're so appreciative of all the time you guys have spent with us. So this was the shortest of our HIPAA huddles, as well as the last. So any other questions that y'all have on what we just shared, or on anything that we've shared over the past 4 weeks?
I'd say this is your chance until the final rules come out, right, Sarah? Because
right.
we're going to move on to other topics.
Right.
So nothing
So
is
while
coming from the chat area.
Yep. So while y'all are writing up your questions, I will let y'all know that tomorrow's HIPAA huddle, which is our normally scheduled huddle, the third Wednesday of every month at 1:00 Central Standard Time, we are going to be going through lessons learned from our experience and our clients' experiences, and working through corrective action plans from the OCR. So if you have not registered yet, you should definitely check it out and register for the regularly scheduled HIPAA huddles.
I did
Also,
get
if
one
you,
question.
oh,
Sorry.
awesome.
Yeah.
Go ahead.
What is the date for the final rule to be published?
That is the $1 million question. I wish I knew. So far, these proposed rules have not yet been published to the Federal Registry. So here is the link for once these are published to the final registry, where you will be able to make comments. So we have no idea when this rule is going to be finalized. Right now, the purpose was for us to let you know what these proposed rules are saying, so you can start to like formulate a plan or understand what the potential final rules could be. And you would also be able to understand what is clarification, so you can go ahead and start implementing those things that are clarification. So you're not in such a big rush when these final rules do come down.
Right, and Sarah, and I think it's good to let everybody know that we plan probably starting in March to do a rural HIPAA huddle starting on the second Tuesday of every month. And so we'll be letting everybody know about that. And of course, when it comes to rural topics, they're the same, but with a twist on some of the greater topics you talk about. So we'll jump into some interesting areas, I think, on that, and it'll hopefully help complement what you're already doing.
Right.
So I have two comments. One was we received this on a listserv today. This is to be published on Thursday morning. So we'll see if that is true.
We'll see. Yeah.
Yep.
Thank you for that, though.
That's great.
Other is, how do we register for the monthly HIPAA huddles? And I will love rural HIPAA huddle. So
okay, so how do you, okay, so first of all, you can register for the regular HIPAA huddle on HIPAAtrek's website by going to HIPAAtrek.com. And there is a link to be able to register for the HIPAA huddle on the website itself. If you follow me on LinkedIn, you can go to my LinkedIn profile, and it is the very first featured post is how to register for the HIPAA huddle. So you can click there. Or if you want, you can shoot us your email and we'll send you the invitation, or go ahead and register you for us, or register you for for the HIPAA huddle. So however you want to do that, we can get you there. And then whoever said they would love the rural HIPAA huddle, thank you. We are so excited about it because I came from rural health. Erin lives in Montana, which is almost like frontier health. It goes beyond rural. So we are very, very excited to be able to partner together, Compliance Stride and HIPAAtrek, to provide this special rural health HIPAA huddle. So very, very excited. So watch for announcements on that. The best way to receive announcements is if you are on LinkedIn, follow me on LinkedIn. Otherwise, you will be receiving monthly emails from us on all things HIPAA huddle. Once you've joined one HIPAA huddle, you get the privilege of getting all the HIPAA huddle information as it gets released. So any other questions? Oh, see, here we go.
Oh, wait, it says 2 new messages. Huh. Yep, sorry, I didn't. So could, yep, I've got an email address. Okay.
Okay, so we will send that. So with the email address, we will go ahead and get you registered. So Cheryl, if you can just take a screenshot or something of that so that I have that information, we will get you registered for that HIPAA huddle tomorrow. So we are very excited about the HIPAA huddle tomorrow. So we have special permission from one of our clients who is in an active corrective action plan with the OCR to share lessons that we've learned. So very, very excited, because hopefully these lessons will prevent you from ever getting a corrective action plan from the OCR. All right, so if there are no other questions, if you want,
there's one more.
Awesome.
Okay, this is a different topic. Do you have
Great.
any additional resources available related to behavioral health records, HIPAA, excuse me, and what to release?
Behavioral health records. So that covers such a wide topic. So if it is behavioral health that is just covered by HIPAA, the answer is yes. If it is behavioral health covered by 42 CFR Part 2, the answer is still yes, but I have more limited information available on that. I would highly recommend that you contact my good friend Erin MacLean to get more information on those pieces. So hopefully that was helpful. And where to get that information, if you would just send me an email, here's my email address, or send Erin an email. Either one of us would be able to help you with this.
And Sarah, what's interesting about these proposed rules is they did highlight that it appears that providers do misunderstand that the mental health records that are not Part 2 records are covered by HIPAA, and they're disclosable, especially for treatment purposes, but in all aspects under the HIPAA rules. So from that perspective, if there's a care coordination or case management that needs to be done and treatment that needs to be done for treatment purposes, that information should be being shared. And again, that sort of falls as the 21st century Cures Act comes around behind HIPAA. For treatment purposes, we should be engaging in the sharing of that information for treatment purposes with other providers, and also with those individuals that are helping care for the individuals that have mental health challenges and are seeking treatment for that. So this proposed rules, the dialogue on that in that area is worth reading, because it really provides clarity on what we should be doing now.
100%. So I think the only thing is the caveat being the psychotherapy notes, right? That's the only carve out in HIPAA for behavioral health.
Right.
So yeah, and then it does get a little stickier under Part 2, but again, Erin or I can provide you that clarification. And if you're looking for the better clarification, I would 100% contact Erin, because I know just enough about Part 2 to be dangerous. So definitely go to Erin. And I also noticed, and I have to apologize to Erin, I misspelled your email address in my super fast hurry of putting this together. I'm missing the I in front of the N.
Yeah.
So it's,
True.
if you are jotting down Erin's email address, it is comaclean@complininstride.com. So I apologize, but it is missing the I in. So yeah, so please feel free to reach out to her with any additional questions on Part 2. Reach out to me if you have any questions, or if you would like for me to put a more formal introduction into Erin, I am happy to do that as well. So awesome, possum. So Cheryl, do we have any other questions?
Nope, that's it.
Thank you guys so much yet again for another amazing HIPAA huddle, and I hope to see y'all again tomorrow.
Thanks, Cheryl and Sarah. It's been fun.
Bye, everybody.
Bye-bye, everybody.
Thanks, everybody.
All right, bye.
Bye.